They don't have to be supported by documentation. They don't have to be objective reasons. It could be, I don't think she was a good fit. And however any of those reasons the defendant comes up with, the burden then shifts back to the plaintiff to show that there is a jury issue, a disputed material fact, as to each and every one of those issues.
Hello and welcome to See You in Court, the podcast that informs you about the Georgia civil justice system, what it means to you, and how it protects individual rights. This podcast is a collaboration between the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Your hosts are Robin Fraser Clark and Lester Tate, who are both past presidents of the State Bar of Georgia and currently serve on the Board of Directors of the Georgia Civil Justice Foundation. And now this episode of See You in Court.
Good morning, friends and lovers of the law, and welcome to See You in Court. I am Robin Fraser Clark, and with me is my co-host, the hell of an engineer, Lester Tate.
Yes, the Yellow Jackets post a big victory after getting a new coach last Saturday night. I'm very, very proud of them. But I also want to say happy birthday to my co-host. I meant to send you a text and call you the other day. Yeah. But yet another trip around the sun, and it's been a great trip around the sun with you as my co-host here on See You in Court.
I totally agree, and I know you had a birthday 2 weeks before mine. We're 2 weeks apart, kindred spirits, and
you're very kind there, Robin, because we're 2 weeks and a couple of years apart.
Oh yeah, right. I forgot about that.
I'm on the older, grayer, but not necessarily wiser end of that. So, but happy birthday to you. And
thank you.
As a thank you to our listeners, I will not sing today. So they don't have to put up with that.
I thought when I introduced you as a hell of an engineer, which means you graduated from Georgia Tech, which is a hell of an accomplishment. But I thought you were going to say, I graduated from Tech, but I'm not an engineer.
I used to say that a lot, but I just don't anymore, because we had to take engineering classes. Yeah. And, you had to take, and I'm not, nor do I aspire to be an engineer. I thought briefly about switching to an engineering major until I got 2 Ds in calculus and an F in chemistry, all of which were required courses for engineering. But I will say that Georgia Tech is a great school to attend, even if you want to go to law school, because I felt law school was pretty easy after 4 years of Georgia Tech, where no one who actually went there says they graduated from. They say they got out. It's like being discharged from the penitentiary. You got out, and so I managed to actually get out.
Yeah, you served your time.
I did,
and got out. Well, today we're delighted to have attorneys Stephen Wolfe and Cheryl Legare with us. We're going to introduce them and talk about all things employment law. Cheryl and Stephen are partners in the Atlanta law firm Legare, Attwood and Wolfe, which specializes in employment law, which is a very interesting practice of law, and I would say very difficult. And we're going to learn about that. But hats off to them for doing this and making this their niche. Let me first introduce you to Cheryl Legare. Her practice focuses on representing employees in all aspects of employment law, including claims of disability discrimination and retaliation, sexual harassment, FMLA, interference and retaliation, gender, pregnancy, race, religion, national origin, age discrimination, and wage and hour disputes. She also represents individuals in contract negotiations and employment separation negotiations. Cheryl is an active member in Georgia Association for Women Lawyers, the Atlanta Bar Association, the State Bar of Georgia. She founded GAWL, that's the Georgia Association of Women Lawyers. She founded their solo and small firm Affinity Group and is a past president of GAWL. Cheryl is also a member of the National Employment Lawyers Association and is a past president of the organization's Georgia chapter. Cheryl is admitted to practice law in Georgia and South Carolina. She is also admitted to the United States District Courts for the Northern and Middle Districts of Georgia and the United States Courts of Appeals for the 4th and 11th Circuits and the United States Supreme Court. Cheryl lives with her cat Dixie and dogs Luna and Molly in Decatur, Georgia. In her spare time, Cheryl enjoys spending time with friends, listening to live music, and traveling. We also have with us Stephen Wolfe. Stephen has devoted his entire legal career to helping individuals stand up to their employers. He helps people fight for overtime pay that their employers have illegally denied them. He helps people overcome unlawful workplace discrimination, harassment, and retaliation, and helps people negotiate severances and new employment contracts. Steve has successfully represented people from all walks of life, from all industries, and on all rungs of the corporate ladder, from entry level to C-level. Steve attended Boston University for undergraduate and then Emory Law School. Steve is married to his wife, Christiane, who is a corporate attorney, has 2 sons, Jake and Caleb, and 2 dogs. Steve loves hiking, photography, and reading history, or anything to do with the space program. He is also more than halfway to his goal of hiking in every national park in North America. You can find out more about Cheryl and Steve at their website, law-llc.com. It's law-llc.com. Cheryl and Steve, welcome to the show.
Thanks very much for having us.
We're glad to have you and glad to be able to talk about this very complex and what I would say is very difficult area of our law that I think a lot of people, including lawyers, don't really understand or have a good grasp of how difficult a job you guys have. So if we could just start, if you don't mind, to talk about a little bit about just employment law basics. Explain to our listeners what kind of cases are employment law cases. I know there's Title VII and discrimination, and I talked a little bit about that in your introductions, but can you fill us in on just kind of the basics there?
Sure. So you've got, and Cheryl, jump in anytime and interrupt me. I mean, you've got several different types of employment cases. Broadly speaking, you've got the overtime, wage hour sort of cases that are under the Fair Labor Standards Act, which is a law that was passed during FDR's administration. Then you've got what I think most people probably think of when they think of employment discrimination, which is Title VII of the Civil Rights Act. That was part of the civil rights legislation in the 1960s. And that's what the most generally applicable law that prohibits things like race discrimination, sexual harassment, gender discrimination at work. And then you've got other statutes as well, that the Americans with Disabilities Act that protects people with disabilities and entitles them to reasonable accommodations. You've got the Family and Medical Leave Act, which sometimes interplays with the ADA and sometimes doesn't. You've got the Age Discrimination in Employment Act, which does exactly what you would think it does, it prohibits age discrimination. And then you've got a lot of these statutes have anti-retaliation provisions attached to them. So they not only make it illegal to discriminate, but they also make it illegal to fire someone for reporting discrimination. And then sometimes you've got sort of subject matter specific or industry specific whistleblower protections that can apply in certain circumstances. I think that generally covers the broad strokes of it.
All right. And y'all do pretty much any of that, I take it. Any kind of case like that in that umbrella, you will represent a client if you think it's a case you can win.
That's right.
Yeah.
So when Robin mentioned my Georgia Tech affiliation starting out, and contrary to what some might think, I actually discovered I really liked the law at Georgia Tech because I took a lot of business law classes. And I still remember sitting in an auditorium one morning when the law professor comes in and he starts talking about this thing called summary judgment, which I'd never heard before. And I was aghast that people actually wouldn't get a jury trial, on anything at that point, because just as I thought bright, I didn't know how ignorant I was, 18-year-old, I thought that, you always get that, but overcoming summary judgment is like so hard in these employment cases. And, I've gotten hired in a lot of cases where employment lawyers, they beat summary judgment. Then they want me to try the case because they've never tried a case. Mm-hmm. But if I were waiting around for that call, I'd starve because, it doesn't happen that much. And so I've since learned that the main thing is there's an issue of fact. It ought to go to the jury. And I think I know how you all feel representing, employers, that the system is sort of employees. I'm sorry, that the system's sort of stacked against you. But, supposedly anything that has a disputed issue as to material fact should go to a jury. Can you explain to me how repeatedly it gets justified in the Northern District and the 11th Circuit that there's no disputed issue of material fact?
You want to go first on this, Cheryl, or you want me to take it?
I wish I could explain it. Something you said, Robin, was so funny to me. Of course, I'm going to take these cases if I think I can win them. But here's the issue. We take the cases knowing that, if you can't get it resolved before summary judgment, there's 85% chance you're going to lose that summary judgment, even if you, and I explain to my clients all the time, I've survived summary judgment on claims I never thought I would, and lost summary judgment over and over again on cases I thought would and should survive. And, I'm a frequent flyer in the 11th Circuit. I appeal if I think I should have won. But where does that really get you when I think their reversal rate right now of the district courts is around 18%?
Yeah.
I feel like that's what a mediator told me, an 11th Circuit mediator told me in the last month or two. But, it doesn't mean I'm not going to fight. You still have to fight. And, let's face it, all of these cases have disputed issues of material fact.
Yeah. And to me, some of what I'm saying, it looks like
judges use these cases as docket clearing measures.
Well, yeah, some of those, it looks like to me that it requires it requires you to actually have written proof, which is, of discrimination, even though that's not anywhere in the law. But, if it's, if you use racial epithets in front of your employees, unless you've sent an email with them in it, it's really hard to get past. Am I misjudging that at all?
You're not misjudging. So the question you asked, you don't need written proof, but you do. But that certainly helps, and it doesn't come by. We don't come by it as often as we wish we would for reasons you can understand, I'm sure. But the first question you asked, Lester, was how is it justified in the Northern District of Georgia? I think is what you asked, and
yes,
and the way I see it is this way. These statutes, all the statutes say, regardless of which one, is it shall be illegal to discriminate based on a protected trait. That's all. They don't define a standard of proof. Generally, they don't define anything more than that broad principle. And so what's developed over the last really several decades, starting from really 1991 when they amended Title VII to allow jury trials, because before the 1991 amendment to the Civil Rights Act, jury trials were not allowed. And in the first few years after that happened, you started having a lot of jury trials because they were accustomed to having a lot of bench trials. And then what started to happen is employers started getting tagged with jury verdicts. And so what's evolved over the last few decades is a massive body of completely judge-made law that consists of ways of granting summary ways of finding that there are no material disputed facts by judicially defining to irrelevancy things that are in fact material disputed facts. And these are things that are not based in the statute. These are all just judge-made ways of analyzing cases that result in dismissal. And before you think I'm being a conspiratorial sort of plaintiff's lawyer, I'll give you one discrete example that comes to mind. And we can talk as much or as little about this as you'd like, but one rule that gets applied in the vast majority of cases, there's some indication that this may change, but it will be a process for it to change. But this has been the rule at summary judgment for decades, is that even if we have a solid prima facie case, even if we got some evidence like Lester, you were saying, maybe we've even got an email that shows racism or shows sexism or whatever the case may be. That doesn't win the case for us. All that does is shift a burden of production to the defense to state any reason that would justify terminating the plaintiff. And there's no limit. It could be 1 reason, 2 reasons, 10 reasons, however many reasons they want to come up with. They don't have to be supported by documentation. They don't have to be objective reasons. It could be, I don't think she was a good fit. And however many of those reasons the defendant comes up with, the burden then shifts back to the plaintiff to show that there is a jury issue, a disputed material fact, as to each and every one of those issues. If you don't, summary judgment can and most often is denied. Now, take the same situation at trial. Imagine at a trial, federal juries are instructed that if a witness is impeached or you don't find their testimony credible, you can disregard any or all of their testimony. You don't have to disregard it all, but you can. And imagine that same case at trial. The defendant gives 3 reasons for letting the plaintiff go. I don't know. She showed up to work late. She turned in her TPS report a week late, and somebody complained about her. And through discovery, I show that she didn't, in fact, turn in the report late. Here's the email that showed she turned it in on time. And she wasn't late to work. Here's her time cards. So jury issues as to both of those. But I can't disprove that somebody complained about her. Most often, a judge will dismiss that case at summary judgment, even if I've got additional evidence that shows that the decision maker had a racial bias. But at trial, if the case got to trial, a jury wouldn't have to, but could see the guy get impeached as to reasons number 1 and 2 and say, well, he's probably lying about 3. Because it's a common sort of human experiential judgment to make, and it's totally within the jury's authority to do that based on how they're instructed. But on a regular basis, cases like I just described are dismissed at summary judgment, and nothing in the statutes say anything about that sort of a dismissal being permitted. So how is it justified? That's one sort of discrete example, but it's a representative example of how this happens. Even though in almost all of these cases, the ultimate issue is what was someone thinking when they made a decision. So it makes it a very difficult playing field.
Yeah, you would think that when you put up your case and then the employer puts up a so-called justification for his actions, by definition, to me, that makes it a jury question at that point.
You would think.
You know what? They've gone farther than that, Robin. There's a doctrine in the 11th Circuit, and it's in other circuits, not all circuits, and not as strong in all circuits, but in the 11th Circuit, there's 2 things, the business judgment rule and the honest good faith belief rule.
Oh, yeah.
Okay, honest good faith belief. Doesn't that sound like a jury question right there?
Oh,
no.
Sure.
Our cases,
it all goes to credibility.
Right. Our cases get kicked out all the time. Literally, I thought in the 11th Circuit, this might not be the exact facts, but they accused the employee of stealing $5,000. The employee didn't really steal $5,000, but they had an honest good faith belief that the employee stole $5,000. So you're out of court. I mean, that's what that means. We don't second guess an employer's business judgment. It's in the jury instructions in employment.
Wow.
Yep.
Yeah. That seems so unfair to the employee.
It really is.
It is. It is. I mean, I recently I've got a case where I'm co-counsel with one of my buddies. We recently got a case past summary judgment where honest good faith belief was part of the defense, but it was a close run thing. It ought not to be. But it was. You could read the opinion. You could see the judge hemming and hawing and hemming and hawing. He finally says, well, okay. But it shouldn't even be a close question when you're talking about the issue coming down to what was someone's subjective intent.
So it seems like too. Go ahead, Robin.
I was going to say, explain a little bit too about in this type of case, when a defendant files a motion for summary judgment, meaning to kick the case out of court, it doesn't even go to your judge first. It goes to a magistrate, correct?
Yes.
Like that doesn't,
100% of the time.
Yeah. How did that happen? Explain that one.
The Northern District of Georgia is the only district in the entire country where this is how it works. In most places, like in the Southern District, for example, and in the Middle District, especially in the Southern District, they'll use magistrate judges for discovery dispute, but not for summary judgment, not for dispositive motions. Positive motions have to go to the district judge because the district judge is appointed and not, for lack of a better word, hired, right?
Right. It's his job.
Right. And somewhere along the line, and it's been a really long time in the Northern District of Georgia, they started, first it was just Title VII cases with the magistrate. Now it's almost all of our cases, not FLSA, but almost all of our cases go to a magistrate judge first. So magistrate rules, and then we file objections, and then the district court, depending on what judge you get, well, they're always supposed to look at it de novo, right? And relook at the record for what you point out, for anything that I point out to them. Some district judges do a more thorough analysis, but often, I'd say most of the time, the magistrate judge's orders are adopted as the order of the court.
Yeah, I was going to ask you what percentage of time does the district court judge just simply adopt I think it's called a report and recommendation, an R&R?
It is. I would say often, I don't know the percentage. I have had, not very often, but had a district judge say, no, there's a disputed fact here. But I've also had, and I'm doing an appeal right now, where the district judge said, yeah, I know that he let it pass summary judgment, but I want summary judgment granted. So.
Yeah.
And so what circuit is probably the I'll say the antithesis of the 11th Circuit or the one that affords employees the most protection? And in saying that, I got to think for a lot of our listeners, the idea that you live in one section of the country versus another section of the country, that you got different rules is probably anathema to what they perceive the rule of law is. But it seems that there are few better examples than in the employment arena.
Yeah. It would be the 9th Circuit. Now that's changed some. What'd you say, Cheryl?
Second Circuit.
Second Circuit's also good. That's the one that's based around New York. The 9th Circuit is centered on California. That's changed some because, we had 4 years of the prior presidential administration that appointed a lot of judges. And now you've sometimes got really sort of schismatic decisions coming out of these other circuits that used to be more uniformly and plaintiff protective and now are becoming less so. But still, it's quite a big difference.
Another, rule or law that may make it more difficult for your success and for your clients is caps on damages in an employment case, which I learned the hard way. Back when I first started my own firm back in 1994, I had an open door policy, meaning if it came in my door, I was taking it. I was taking the case. And I took a sexual harassment case that I learned by reading the statute. And my demand was $50,000 and they offered zero. And we tried it and I got a $1.5 million verdict that was within 24 hours reduced to $350,000. So immediately I had a bad taste in my mouth about practicing employment law and I didn't do it much after that. So can you talk to our listeners about that law and Why do we have it, and what is it? It's hard to understand.
So first of all, damages caps are unconstitutional. Let's start there.
Agree. Totally agree.
But
totally.
Under Title VII, so it started with the 1991 Civil Rights Act. So the 1991 Civil Rights Act, which was a big amendment to the 1964 Civil Rights Act, it on balance did a very good thing, which is it created jury trials, a right to a jury trial in Title VII cases, which hadn't previously existed. However, I can only assume, as a bone to the corporate lobby, it capped damages. And the damages are capped based on the number of employees a company has, with the maximum allowable total compensatory and punitive damages together being $300,000 for a company of 500 or more. And they've never been updated since 1991. They're not keyed to inflation or cost of living increases or anything like that. So just to give you an idea, I knew I was coming on this morning, so I looked it up this morning that $1 in 1991 would be worth $2.17 today, which means that if they did not, even if they kept the damages caps in place, if they simply had raised them all along to keep up with the cost of with the rises of inflation, your $300,000 damages cap today would be more than double that. Still not nearly enough to make people whole, but at least we're keeping up with inflation. Mm-hmm. And this becomes a huge problem for all the reasons you would imagine. I mean, it reduces employers' exposure, it caps employers' exposure. And in most cases, what it does is it ends up making the major driver of value be lost wages, rather than emotional and punitive damages, because they're capped. And most people are not that highly compensated. We have some clients who are executives who end up getting better relief in terms of dollars because their higher compensation drives a damages calculation. But a lot of our clients are hourly workers or people who just make a normal, middle, lower class living. I mean, if you could have the most damning discrimination case, in terms of liability evidence, that would also translate into a punitive award, right? Because a bunch of horrible racial comments would be a basis for a punitive damages award. But at the end of the day, if the most that you can subject the employer to is $100,000 in lost wages, something like this, plus $300K in cap damages, plus whatever attorney's fees you've accrued, it's not that scary to a major company. And it sets up a situation in your settlement negotiations where the lost wages become sort of the employer's ceiling on what it's willing to pay. And so then they're negotiating down a gross settlement number, which is based on the actual lost wages to date. And so that doesn't come anywhere. A settlement like that comes nowhere close to making a person whole, even for just their lost out-of-pocket wages. So it's very difficult.
So one of the other things that in my dabbling, I after trying to negotiate through the summary judgment, all the law and everything. I mean, I told my staff, next time I think about taking an employment case, lock me in a closet with only phone books to read and let me tear up $100 bills till the feeling goes away. But I kept, I had a couple of folks, had two younger lawyers who got past summary judgment on claim, and they call me, they've got to go to trial, and I enter my appearance, and then the case settles immediately. Had another one where something like that happened. I'm thinking, I've got this great reputation as a trial lawyer. That's why I was. Then I had a case with one of these lawyers who had been in a big firm, had defended folks. He goes, oh, no, they just don't have anybody that's ever tried a case. If you get past summary judgment, it's going to settle anyway. And so it had absolutely nothing to do with me, much to the regret of my inflated ego at that point. But, I guess what I want to ask you is if summary judgment obviously kicks you out of court, and then if you get past summary judgment, you got all those caps, to try to overcome. which is going to limit what you're going to get in trial. I mean, isn't summary judgment just sort of dispositive of the case one way or another? I mean, isn't it gonna, it's almost never going to go to trial, it seems to me.
It often is. It often is. It's not always, but it often is.
I think it depends. It's a hard question. Common wisdom.
I feel like I've left you speechless, Cheryl.
Well, common wisdom is you survive summary judgment, you settle, but that's not happening as much as it used to. And if you think about it, I feel like there's inherent conflicts in employment cases, because if defense attorneys recommend settlement in a jurisdiction where summary judgment is granted so frequently, regardless of the merits of the case, is that even something a defense attorney should do? I've had one case in 20 years where they haven't moved for summary judgment. And I don't think that's what summary judgment was ever meant to be. But now, and it may just be the cases that I have right now, they don't seem to be settling. Now, part of that I think is hard because our clients are super inclined to settle once they've survived summary judgment, because we spend the entire length of the case, which sometimes frankly goes on for 9 years, telling them, you're going to lose it. There's a good chance you're going to lose at summary judgment. You'll never get this case appealed. I have one. It's 9 years old. She doesn't want to settle. She wants to let the jury decide. And so and that's why, if I seem like I'm struggling, that's why, because I still think settlement is normally the best way to go. But I will also tell you what makes it really hard to settle after summary judgment is defense attorneys think they should make us jump through all the hoops to get past summary judgment and then cut our fee to 1/4 of what it is in order to settle. They don't offer realistic money to settle before trial because they don't see why I should get paid, even though they got paid all along. And that sounds very jaded, and perhaps I'm feeling a little jaded right now. But
well, yeah. I mean, so just the caps are not always in play. I mean, these laws are a patchwork, and so there are, maybe not more often not, but there are often times when you can plead alternative claims or claims that are not subject to the caps. And if you get claims like that past summary judgment, you're obviously in a different playing field in terms of your leverage approaching a trial. But it often is summary judgment. It ought not to be, but it often is a watershed moment in the case because, for the reason you just said, I mean, both defense lawyers mostly don't try cases and don't know how to and are terrified of it. For us, it's the most fun we get to have, but we rarely get to have it. And oftentimes the cases that we end up trying are against governmental defendants. Private corporations tend, either they've got insurance, which sort of, takes over as a negotiating lever, or they're just more pragmatic. But the local government entities, there's politics involved, and they require board approval and things like this. And sometimes they're just not able to reach settlements. And so a lot of the cases that we end up trying, not all by any stretch, but a lot of the cases we end up trying end up being against governments, not because we preferentially sue them. In fact, they're a minority of the cases that we have, but they end up being a disproportionate number of the trials that we have, just because they tend not to settle as often.
Well, the caps on damages certainly don't, when you do have a caps case, it doesn't incentivize an employer to behave properly. Because they think, hey, even if I do the worst and I just fire this person because of their skin color, what's the worst that can happen? 300,000? No biggie.
I'll tell you I was thinking about this when I was thinking about coming on this morning. I had a conversation with a lawyer she was a very, very, very good defense lawyer. I was probably a second or maybe third year lawyer at this point. And in federal court, when you file a lawsuit, one of the very first things you do is you file something called a certificate of interested persons. It's like usually a one-page thing where each side just lists the people and entities that have a financial stake in the outcome of the case, right? And as a matter of course, that's the parties to the case, and maybe you list the lawyers, and that's it, right? And this particular lawyer was representing a large company and didn't list her own client on the certificate of interested persons as having a financial outcome, a financial stake in the outcome of the business. And I was, a plucky 27-year-old version of myself or what have you. So I called up the lawyer and I said, look, I'm not trying to pick a fight over some hyper technical thing, but why didn't you list your client as having a stake in the outcome? And she just very matter of factly explained that, I had a highly compensated client, and she just very matter of factly explained that, look, your best day in court is your client's lost wages plus $300K in your fees. And my client's balance sheets and cash flow statements don't go out to enough decimal places for that to register. So they don't have a financial stake in the outcome. And that was an eye-opening. She was just being matter of fact. She wasn't, chest thumping or anything, but that was a very eye-opening conversation for a young Steve Wolfe.
She may not have been chest thumping, but you still want to smack the crap out of her, don't you?
I sure did.
There are, to clarify one thing, though, there's a statute 42 USC 1981, and for rape cases, there is not a cap.
Right.
Oh, okay.
And it's the only type of case that there isn't. And for age and Family Medical Leave Act cases, they don't get compensatory or punitive damages at all. They get wage-based damages. And if you prove that the conduct was willful, you get 2 times the wages.
So, and Robin and I do a lot of, tort work, plaintiffs, personal injury stuff. And the plaintiffs bar, in the plaintiffs bar about, starting from January when the legislature goes into session until, May or whatever, when they leave, about once every 2 or 3 weeks, we get a email, from all our colleagues that says, I heard somebody whisper the word tort reform at the Capitol today. We need to burn $100,000 on the Capitol lawn before sundown. Who will put the money in, And, we all go marching down there with pitchforks and torches and, hopefully quail the tort reform. And if you put a scheme like this, like you all have described, and you all labor in the vineyards under, which garners my undying respect, on plaintiffs' lawyers. Torches and pitchforks. We'd probably have the plaintiffs' militia down there or something, Yeah. How has this not gotten changed in an era really before? I know now it's federal law. There's a lot of gridlock, with the parties and with a closely divided Congress. But it just seems to me that this is the kind of thing that ought to be legislatively fixed, or should have been at some point along the line. So why hasn't that happened? And is there any movement afoot to try to change that in the future?
So statewide, I would say this. California has a lot of state laws. Florida has state laws. Georgia does not. And it's not anything that we've been able to get any kind of traction on because Chamber of Commerce lives down at the Gold Dome.
So you're saying there's no Georgia state law that prohibits discrimination. Is that right?
It's essentially right. And
okay.
The only reason I say that is there's a little bit of state law with not much teeth to it that applies to state employees that we don't use to sue because it wouldn't be worth it. There's
Gotcha.
Individual right of action here. No damages there. But California is known as being one of the most plaintiff-friendly venues because they have a ton of state laws. All the Northeast states have state laws that protect employees, and some of the cities, right? In New York City, you have New York City laws that protect you, New York state laws that protect you, plus federal laws. And a lot of times they forego even using the federal laws to try their cases in state court. Missouri, of all places. Most of their cases are filed in state court under their state laws because they're more protective of employees than the federal laws. And I don't know, Lester, how we could get any traction to change the laws federally, because that's what really needs to happen. We were talking about it, and I know it's a pipe dream, and I'm too old, and I'm going to be dead before it happens, but I don't think summary judgment should be a thing, right? These are intense causes of action. How can anyone but a jury decide that, in my opinion? But we don't have the money. The plaintiff's employment bar doesn't have the money or any of the resources to get this through when you're fighting the chamber.
Yeah, I mean, there is some movement. I mean, Congress, they recently passed a statute that prohibited mandatory arbitration in sexual harassment cases. That was a response to the Me Too movement, which was a big win for employees. I'd love to see them expand that to say that, there should just be no mandatory employment arbitration, full stop, because there are plenty of other people who are, in a similar position of having no leverage, but just have different types of claims. And every once in a while, you do get a surprisingly good decision. I mean, it was just a couple of years ago, the Supreme Court handed down the Bostock decision that held that gays and lesbians are protected by Title VII, and it also had a lot of good reasoning in it that applies more broadly, although it's yet to sort of make its way through all the courts. But yeah, I mean, a lot of these things on the plus side, a lot of what's wrong is not constitutional, and so it's subject to a legislative fix. On the other, the downside is legislative fixes are hard to come by in the current political environment, like you said, and Walmart and Amazon have pretty good lobbies, and so does the Chamber of Commerce, and it's difficult to get like a really widespread reform where they would go through and sort of do what they sometimes do when a really bad Supreme Court decision comes out. They'll legislatively change it to fix the law back to what Congress intended it to be. I think if most of the public had an understanding of what judges say their rights are in federal court as employees versus what they imagine them to be, there would be a broader public outcry. But fortunately, most people don't have to interact with this part of the justice system. And so on a daily basis, it doesn't come home to them, how many times a woman can be touched by her boss at work before a judge will say that it rises to being a sexual harassment claim that's actionable, for example. So, unless or until you get that sort of, I think, groundswell of support, it'd be difficult to make widespread change.
We often hear this kind of blanket statement that Georgia is an employment at will state. Does that play a role in whether you're successful in your discrimination cases? Does that play any role, or do you just ignore that for your cases?
It doesn't really play a role in our cases. I mean, the rule is you can be fired for a good reason or bad reason, just not an illegal reason. And if they're violating Title VII, legal reason.
Okay.
Not really.
All right. Then there's some case law that we haven't really touched on yet, where the law requires you to show other people called comparators in the same or I guess similar situation as your client to prevail. Can you talk a little bit about that and why do we have that? And it seems to me it's the only type of case where you have to do that.
So you don't actually have to.
Okay.
And thank God.
Yeah.
You can. You can show, one of the ways that you can show discrimination is by showing a comparator, i.e. somebody who is, outside of the protected class that your client is in and in a similar situation, but was treated better, right? You can show it that way. You don't have to. And one of the ways that the 11th Circuit has actually been pretty good recently is they've made pretty clear that you don't actually need a comparator anymore, even in cases where traditionally you might have had to have one. District judges don't often or sometimes feel like they don't have to apply that. But it's fortunate because proving a comparator is extremely difficult. They've made it extremely difficult. And this is another example of the sort of how judge-made law at summary judgment makes cases harder to get past summary judgment than they would be to win at trial. Because in order for a court to even consider your comparator as evidence at summary judgment, they have to be, I forget what the exact phrasing is, similar in all relevant respects
similarly situated in all material respects.
Similarly situated in all material respects to your client, but outside the protected class. So first of all, there's many jobs where there's just not somebody similarly situated than you. You're the only person that has your exact job in the company, right? And things as small as a few years different level of experience in the job, or a difference in one or two levels in the hierarchy, or they say your client was fired for being late to work 3 times. Your comparator was only late to work once, so they're not a comparator. Things like, these are things.
You can take it to an even worse extreme than the courts have. Let's say you have one of our clients is terminated allegedly for attendance issues, and they've retained 5 employees who got in fights at work. They're not comparators.
Right. It has to be the same kind. If your client is fired for some sort of wrongdoing, it has to be the same. Your comparator has to have done the same type of wrongdoing. It plays into summary judgment, right? Because at summary judgment, the only question the court has the business of asking is, could a reasonable jury find liability? If the answer is yes, summary judgment, that's the end of the inquiry. And when you present a case at trial, jurors are not instructed on a comparator standard or any such thing. If the comparator has been ruled in, which happens in a very small minority of cases, but if the comparator is ruled in, you just present the comparator evidence at trial, and it's up to the jury to decide whether they're persuaded or not. A jury isn't instructed on, and wouldn't anyway, go through the analysis of, okay, before I consider whether the guy in the blue shirt is a comparator to the plaintiff who was wearing a white shirt, first I have to make a list of all the material similarities and decide whether they're the same or different. No, it would be a sliding scale, right? This is the way. If you have a lot of strong evidence of intent, a weaker comparator might end up being persuasive. If you've got no evidence of intent and your entire case is riding on the comparator, that's a harder case. And ordinary people with common experience sitting on a jury would easily understand this intuitively, but at summary judgment, it's just another example of the judge-made law that gets employed against us.
And when you say judge-made law, just to make sure we understand, that means that requirement's not in the statute. It's correct. What the judges have said you've got to do.
That's correct.
Okay. And isn't that the definition of an activist judge?
It's called legislating from the bench, I think.
Exactly. Yeah. Which I thought they weren't supposed to do.
It is an interesting peculiarity of our area of law that the interests that generally oppose judicial activism have established a favorable body of law that arose from judicial activism.
Yeah. Another word would be hypocritical.
That would also be a good word for it.
Right. Yeah.
So another interesting sort of tactical thing, and I was, you're talking about comparators, which are, discrimination by definition is being treated differently from all the other people that you have. And of course, some of the defendants are major corporations, might have offices in 30 to 50 states and have a lot of similarly situated employees. It strikes me that the records of what these comparator employees might have gotten away with or not gotten away with over time is all in the hands of the defendant here. And you can make a discovery request and people, discovery process. I mean, I think it's one of those things. It's sort of like when we had service by snail mail, I'm sort of amazed that it worked as well as it did. I think I'm not saying people don't, that they're not more litigants that are abiding by the discovery rules than are trying to abuse them. But this seems like a real case that's sort of ripe for abuse there, because basically the ticket to a jury trial is, it's like Willy Wonka and the magic ticket. It may be hidden somewhere up in all that discovery, and you've got to go through that, and you got to have somebody go look for it that wants to find it instead of somebody that just, I don't know about any of these other employees. We could go look, but so talk about just a little bit about, is that an issue, or am I just spitballing here?
No, it's a huge issue. It's a huge issue. And part of the issue now is with proportional discovery in federal court. You're going to get an objection that it's not proportional to ask for disciplinary information on everyone in a plant, for example.
Right.
Or especially if you try and go outside the facility where the employee works, you're almost never going to get that anymore. And comparators are, like, let's say there's only one director of accounts receivable. So the defendant's going to say, oh, no, there's only one person in that position. You don't get files from any other employees. And depending on which magistrate judge you get, it's a crapshoot whether you're going to get them or not. So, it is ripe for discovery, difficult discovery.
That's another, you brought up proportional discovery, and thank God we don't have that in Georgia state courts. But I thought that was, again, usurping the jury's role and your role as plaintiff's counsel, because it's your case. You decide what you need. I mean, the judge shouldn't get to decide whether you need to see a document or what's important to your case to prove your case. But it seems like another handcuff on plaintiff's attorneys to be able to get the documents they need in discovery to be able to prove their case.
Yeah, thankfully, I have not had the proportional discovery invoked against me. I mean, I've had people raise the objection, but I've not had it actually applied against me by a court yet. But there is a nice little feedback loop there, right? Like, the value of your case is capped, and so it's a quote unquote low value case. So your discovery needs to be proportional to the value of your case, but you need broad discovery to prove it because it's an inherently hard thing to prove. It's a wonderful little catch-22, but thankfully I haven't encountered that yet. The objections that we run into much more often in discovery are things like just, the usual, it's irrelevant, or it's outside the scope,
overly broad,
or some such nonsense. And, then
they're not a comparator.
Or they're not a comparator because they reported to John and your client reported to Bob or something like that.
Oh, my goodness.
Yeah. And that magistrate process, by the way, they also handle the discovery. So the discovery process for handling a dispute in most federal court, for most judges in the Northern District of Georgia now, is that before you're allowed to file a motion to compel, you first have to confer with the other side, of course. We would do that anyway. But then you are not allowed to file a motion to compel until you've first had a telephone conference or sometimes a Zoom hearing with the magistrate judge, who typically will not enter a ruling, but will give you a preview of what their ruling is likely to be if you file a motion, and perhaps give you a gentle reminder that the party that loses a discovery motion in federal court can be made to pay the other side's attorney's fees for handling the discovery dispute, for having to brief the discovery dispute. Now, and then then you're faced with an obviously difficult set of choices, right? Do you file the motion that the judge has just told you she or she is going to deny? If you don't, under the rules of the 11th Circuit, merely by having that phone conference, you've not preserved the issue for appeal, right? So merely to preserve the issue for appeal, you have to have the phone conference, file the motion. Then if you lose the motion with the magistrate judge, file the motion with the district judge, and only then have you preserved the discovery objection for appeal. So it is, and as you pointed out, Lester, most of our cases are guerrilla warfare, right? Most of our cases, in terms of the evidence that we have when we're starting out, we got what's in our client's head, whatever the client may have brought with them from work before they cut off his or her email access the day they fired him. Maybe we're fortunate enough that there's a few ex-employees who are willing to talk with us and share their experiences, but that's typically it. And the defense has got access to all the corporate records, all the witnesses who are still employed, all the witnesses who are no longer there but may have been severed out with agreements requiring them to cooperate with the company in litigation, which is pretty common. It's it's pretty easy to get witnesses to cooperate when you sit down with them in the corporate conference room with their boss standing outside and say, tell me all the bad things that you ever heard about the plaintiff. So you really have to play, it's a guerrilla fight. You're the underdog and they've got the resources and it's a dogfight every time.
One other topic I wanted to mention and talk about a little bit was sexual harassment cases and the disconnect between what ordinary walking around human beings who are employees think is sexual harassment versus what actually gets you past summary judgment and helps you win a case. Is there a disparity there between what normal people would think versus what really has to happen to have a case?
Yes.
Can you tell us a little bit about that?
Go ahead.
We call it around here, you get one free butt grab.
I wish it was only one.
I know, I wish it was only one. I mean, part of it is, here's what's not sexual harassment. If anyone's listening to this podcast and is not a lawyer or is a lawyer and doesn't practice this area of law, if your boss asks you out and you reject them, that's not sexual harassment.
Well, it's worse than that. I mean, we get, there are cases, if you want to go through the, sort of like parade of horribles, just hop on your LexisNexis and search 11th Circuit and Northern District of Georgia decisions on sexual harassment, and you will find case after case where, the boss only made, a half a dozen sexual comments to his subordinate over the course of a few months and only touched her breasts once. And so the court is not here to be a public civility board or whatever that phrase they use. Summary judgment granted.
Did it used to have to be, maybe it still is, severe and pervasive? Is that still the language?
It's
severe or pervasive.
Severe or pervasive. Okay.
But,
this is our Halloween, our very scary Halloween legal show here. Like we're going in the haunted house here.
I mean, one of the hardest conversations.
A lot of plaintiffs' lawyers that I know who do sexual harassment cases have stopped using Title VII and started filing them in state court. And that's been going on for years.
Mm-hmm.
But this is one area where it really depends on what judges you draw.
That's true.
And I take it that sexual harassment, actionable sexual harassment in Georgia is different than actionable sexual harassment in California or New York.
Oh, without question.
Because of the differences in the federal circuits. Yeah.
Without question. But I don't think there's a single judge in the Northern District who sees it the same way, right? I mean, there are some judges who will do what the 11th Circuit has done on occasion, but not all occasions, which is say, no, only happened 16 times, it has to happen 18, right? Literally, like there's people who, I can't tell you how many briefs I've seen where it said, well, I counted, and instead of looking at the totality of the circumstances, which is frankly what under the law they're required to do, under the totality, they're saying, but. Mm-hmm. And I put some of this on the circuit court that they've made it hard for the district court to do what the district courts want to do. And they have not kept up with norms because a lot of these cases are really old.
Yeah.
Me too.
And sensibilities in the workplace have changed.
Absolutely.
That's right.
They've evolved.
Yeah,
that's right.
A lot of the so-called landmark cases that they cite for what constitutes actionable harassment are cases that were decided in the 80s or the early 90s. The attitudes have changed quite a bit since then about what should be permitted, but the law has not kept up.
I've heard district judges say on this issue, my hands are tied by the circuit opinion. I don't think it's right, but I know I'll get reversed if I don't.
So when you guys decide to take a sexual harassment case, does it basically have to be rape?
No. It doesn't have to be like that.
Not that bad. Somewhere between rape and groping.
It has to be.
I will tell you, sexual harassment cases are the cases that settle most often.
And is that because they don't want the publicity?
I think that's a part of it.
Yeah.
It can be. And it's also, it also is, I mean, in a world where all the cases are fact specific, notwithstanding the court's best efforts to make them not be, sexual harassment is particularly because it comes down to things like the exact words that were used.
Yeah.
How close was he standing when he did some such terrible thing? And you've got, and in a sexual harassment case, you don't often have to grapple with the issue of proving subjective intent the way you do in like in an illegal termination case, because the intent is sort of apparent from the actions, right? So you don't have to sort of prove what was in his head. I mean, if he's grabbing a woman, it's pretty apparent he's grabbing.
You know what he was thinking.
Right.
We're hoping.
Right. We're hoping. They are some of our better cases though, and there's God bless the employers of the world. There's no shortage of them.
A lot of them out there, huh?
Mm-hmm.
Let me ask each of you this. You've both had your careers and still just working on employment law. You've decided that's how you wanted to practice law and the cases you want to specialize in. First, I'll start with you, Cheryl. Looking back on your career, do you have a favorite case or trial that you go, okay, there it was. That's why I do what I do. That special moment.
Well, so it's all the little cases. It's twofold. For all the little cases where I do a lot of disability work, and a lot of my clients have cancer. And when I can help them in any way, even if it's just talking to the employer and getting the accommodation for them that they need so they can get the treatment they need so that they can be able to work full time. Those are the ones. Those are the reasons I do what I do. I think my favorite trial was down in Columbus. We sued the Muskogee County Sheriff, and they found that my clients, both of them were discriminated against because of their gender, and one of them was the equitable relief was that she got the next captain's position, which she got within months because one of the captains sadly died, and so she got promoted almost right away. But even better than that is she felt empowered to retire and run against the sheriff who had discriminated against her and beat him. So that was pretty awesome.
We call that poetic justice.
She got beat the next time around in an election, but she was sheriff for a while, and apparently from everyone I know, she did a really good job.
That's cool.
But it's the little things that don't even make it into litigation that I think are probably some of the best wins we get.
Steve, how about you, Steve?
A favorite case or trial?
Yeah.
I mean, it's hard to pick just one, but since you're asking me, I mean, one of my other partners, Eleanor Attwood, and I, she's one of my best friends in the world. We've known each other for 20 some odd years. We tried a sexual harassment case together not too long before the pandemic. I think it was 2018 maybe, and got a $1.25 million verdict for our client, and everything about we were. The stars just aligned. I mean, you had a stubborn defendant that they just couldn't see it coming, couldn't imagine how they could lose, which is one of the best kinds of defendants to try a case against. And we had a client who just had a memory like a steel trap and was unflappable on cross-examination. She cross-examined, I think, for 4 hours, and just ate the defense lawyer for breakfast and lunch because she was on the stand for a while. And we had you spend all the, you guys know, you spend so much time preparing your client. And then the moment comes and you're powerless, right? In the moment, there's nothing you can do. And you're just sitting there and
you can pray.
If you sit there and pray, and you hope the jury doesn't see you praying, even though you're sitting right next to the jury, you pray in absolute stillness. And our client in this case gave the single best answer that I've ever heard a client give on cross-examination. The defense lawyer had this sort of theory that our client viewed herself as being special and different than everyone else in her department, and that this was really just, she was just, out to grind an axe against her employer, and it didn't, and that's why she sued them. And she had it might have been a 25 or 30-minute line of questioning that was going nowhere, but she persisted on with it. And she asked this sort of dramatic, culminating question. She's standing she's right up against the jury rail. I had the seat closest to the jury box. So I'm right now, I'm 2-3 feet away from the closest juror, watching this go on. And the culminating question for this line of cross-examination is something like, now, so what was it that made you think you were so different and special than everyone else? And our client, who we had not prepped for this question because we never would have imagined she would be asked it, she just calmly looks at me and looks at Eleanor and looks right at the defense lawyer and goes, well, I was the only one that was being sexually harassed and retaliated against for reporting it to HR. And the defense lawyer let out an audible, ugh. And that was probably the case right there. So,
game over.
Yeah.
Mic drop.
So I'll remember that probably.
That's a good one. If you are mentoring a young attorney in Georgia starting out, what would you tell them about practicing in your area of practice of employment discrimination? Yay or nay?
We have 3 young associates, so if you have some thick skin, I think it can be worth it. It's not. You're never going to have a private plane in this practice area, And if that's your goal, then you're not in the right one.
Yeah, I would think you do have to have some thick skin with what you guys do, and a desire to brush the dirt off your jersey and get back up and go right back in there, right?
Yes.
Yep.
Every day. Take a vacation if you need it. That's one thing I'm telling young lawyers in all practice areas. Take your vacation.
Absolutely.
Good idea. Back when I started and Lester started, it was just the opposite. You never took a vacation. You'd be ready to get fired.
Yep.
We didn't know what mental health meant back then, but fortunately, we're all evolving. I'm glad to hear. Well, it's been wonderful talking with both of you, but we end our podcast with every guest. We ask this final question, and that is, how do you define justice, or what does justice mean to you? So I'm going to ask both of you that. Cheryl, ladies first.
I knew you were going to ask this question, and I find it such a difficult question right now, kind of in the world.
Why we ask it.
In the practice area that I practice in, I think justice for employees would be if Congress got rid of summary judgment in employment cases. I want my clients to get their day in court, and frankly, I think most of these cases would settle if there was no such thing as summary judgment. So.
I've always said get rid of it in all cases. I mean, you can get a directed verdict if you're really entitled to it.
Yeah.
That's right. And
I think it would settle a lot more cases too.
Yeah, the settlement rate would be higher.
Absolutely.
Would be higher. Yeah.
But I don't, I hate having to tell people who come through the door, I would love to represent you. You need to know that there's a really good chance we're going to lose. You're not going to see justice. And that breaks my heart every time. So get rid of summary judgment.
All right. Steve, how about you? How do you define justice?
Oh, man. I don't know if I have a succinct philosophical answer, although I did think about it a lot before I came over here. I mean, I would say, at least as it pertains to my field, which is not quite the question you're asking me, but maybe the best I can muster, I would say it would be for there to be no relationship between your financial resources and how you're treated by a court. When you look at when you look at the way summary judgment goes on, when it's corporation versus corporation suing each other, and you look at how summary judgment goes on when it's an individual person suing a corporation, or when it's an individual suing a police officer, ours is not the only field that has this meat grinder to it. I mean, that's fun. You see it. I just think that's an underlying problem that carries. It's why the damages caps haven't been improved. Why hasn't Congress made legislative fixes? Why does summary judgment creep in the direction of the corporation but rarely push back in the direction of the employee? It's one of the underlying causes of all of this is that there is, your financial status affects how you're treated by the law at every point where the law touches people. And I think if you decoupled those relationships, I think you would have something more approaching justice, at least for our clients.
Yeah, and that's a great point. That should never. That is never justice when it's the little guy against the big guy, and the little guy has a bigger burden just because of he's little. Yep. It's supposed to be an even playing field. Everybody's on the same level in a courtroom, but in employment law, it doesn't seem like it's like that. The deck is stacked when you walk into the court against your client. So that is a tough realization to deal with.
It is. That's why it's a guerrilla fight.
Yeah.
You just have to come at the cases differently than you can come at the cases when it's, a piece of business litigation or something like that. You just win by being more aggressive, frankly.
Yeah.
More selective and then really, really aggressive.
Well, that's wonderful to know, and it's been great talking with both you, Cheryl and Steve. Again, we've been talking with attorneys Stephen Wolfe and Cheryl Legare with the Atlanta law firm Legare, Attwood and Wolfe, and you can find out again more about their firm and Cheryl and Steve at their website law-llc.com. Cheryl and Steve, thank you both for being guests on the show today. We appreciate it.
Thank you so much for having us on.
All right, Lester, we have this special time in our podcast now where we both have found an interesting law-related incident or event or article that we want to bring to the attention of our listeners, and you're first.
Well, what I want to commemorate today is, since it is October, not only Halloween, and maybe a scary month in the law, as we talked with our guests earlier, but it's also the month which the United States Supreme Court reopens its session, which runs from October through June, I think, or through May. And so the article I want to share today, and I want to talk about what the article says, but I want to encourage people to read the article with sort of an open eye. But it's an October 1st, 2022 editorial board opinion in the New York Times entitled "The Supreme Court Isn't Listening, and It's No Secret Why." And it begins by recounting that this year, as the justices prepare to open a new term on Monday, fewer Americans have confidence in the court than ever before recorded. In a Gallup poll taken in June before the court overturned Roe versus Wade with Dobbs versus Jackson Women's Healthcare Organization, only 25% of the respondents said they had a high degree of confidence in the institution. That number is down from 50% in 2001, just months after the hugely controversial 5-4 ruling in Bush versus Gore. It goes on to recount some of the decisions that have been made by the Supreme Court, and also quotes Chief Justice John Roberts, who I think has done a lot to try to bolster or maintain the court's reputation as a public institution. And this is the quote from Chief Justice Roberts. And I want to point out that I admire him for what he's done to try to bolster the court's reputation, because I disagree, and this opinion disagrees with what he says. Chief Justice Roberts recently suggested that the court's low public opinion is nothing more than sour grapes by those on the short end of recent rulings. Simply because people disagree with an opinion is not a basis for criticizing the legitimacy of the court, he said in remarks at a judicial conference earlier in September. The editorial opinion of the New York Times goes on to say this is disingenuous. The court's biggest decisions have always angered one group of people or another. Conservatives were upset, for instance, with rulings in Brown versus Board of Education, which barred racial segregation, and Oberfeld versus Hodges, which established a constitutional right to same-sex marriage. Meanwhile, liberals were infuriated by Bush versus Gore, and Citizens United versus the FEC, which opened the floodgates to dark money in politics. The article goes on to say that the actual cause of its historic unpopularity is no secret. Over the past several years, the court has been transformed into a judicial arm, and it mentions the Republican Party. I think we could also say in some instances the justices are appointed because they're believed to be an arm of the Democratic Party. But my point is, I think you and I, Robin, have belonged to a lot of organizations, and one of the things we try to do on this broadcast is to build respect for the courts. And one of the things that is becoming obvious to everyone over the last several years is that the personnel on the Supreme Court matters more than what the law is or has been over the last 50, 75, 100 years. And I don't think it's just sour grapes. And I think that those of us who cherish the rule of law need to realize that when you're saying, the law is what the law is, regardless of who the judge is, I think that strikes a note of disingenuousness to the folks who are listening. So I highly commend this article to people, even people who would disagree with the way that the finger is particularly pointed here, because I think it makes an important point. The law ought to be the law, not who the judge is.
Yeah, it reminds me of our episode that we had Professor Eric Siegel on, who makes the argument that the United States Supreme Court is not even a court, and that's been a couple of years ago. And as we approached Hobbs, now we're past Hobbs, and Roe v. Wade was overruled. I started thinking about that. And I think Eric Siegel was onto something. I think he may have been right.
Yeah, I think that legal scholarship is reeling right now to try to find some coherent rule of law philosophy that would justify all of what has happened in the last several years, because I don't think there's one that's out there. It's not originalism. It's not the living right. Constitution. It's, there is no philosophy that I think does that. And I, unfortunately, am at the place where I think that you have 9 justices who are probably putting their own personal take on public policy ahead of what the law is. Yeah.
Great point. Well, my tidbit in the news is about a case. It's actually a criminal case. We may have talked about it before a while back, but it's the case of Joey Watkins. And Joey Watkins has been in prison for the murder of a person. The murder occurred over 20 years ago. He's been in prison since 2001. So he was convicted when he was 20 years old. And now he was convicted in 2001. It's now 2022. So he's been in prison that whole time for murder. Today in the Georgia Supreme Court courtroom, his habeas corpus appeal was argued. And it's very interesting to me because the Georgia Innocence Project got involved in this case and really made a difference. I read the trial court, the habeas court's opinion, which was issued back in April of this year and granted habeas. And shockingly to me, the Attorney General's office appealed the granting of habeas corpus. And that's why we're in the Supreme Court. And his case was argued this morning. For our listeners, you can go back and listen and watch that oral argument that occurred this morning at gasupreme.us. That's our Georgia Court of Appeals website. But
Georgia Supreme Court website.
Georgia Supreme Court, I'm sorry. Yes, gasupreme.us. And hit oral arguments. And all of their oral arguments are there. And you can watch even older ones. But I bring up Joey Watkins' case because of a couple of things. The habeas court ruled that the habeas should be granted on 3 different reasons, any one of which should grant him a new trial and habeas relief, get him out of prison. One of the reasons was a juror. This involved Joey Watkins getting in his truck and driving from his home in Floyd County up to Rome, where the shooting occurred, which is a 45-minute drive. And yet cell phone towers showed that he could not possibly have made a call, his last cell phone call from the tower where he lived, and make it up 45 minutes up to Rome in time to commit the murder. And a juror on the weekend, while they were deliberating, made that drive herself and then came in and told the jurors, well, look, I made the drive myself and I know you can do it. And she made it on a Sunday, not at the same time of day, but she did her own testing of the drive and gave her own testimony to her fellow jurors. Admitted that in the habeas proceeding. It was a 3-day habeas hearing, and she testified and admitted she did it. It's a pediatrician. So the judge said, no, we can't let jurors go out and do their own test and then tell the other jurors how it came out. But even maybe the second reason, which is also just as, I think maybe more flabbergasting, involves the death of a dog. They call it the grave dog, that was found on the grave of this man who was murdered. And it turns out that the GBI had done like an autopsy. I know it's called something else for an animal, but had x-rayed the dog, had actually removed a bullet from between the eyes of the dog's skull, had that bullet and never produced it to the defense, and never gave them any information about having x-rayed the dog, produced that they had the possession of the bullet, that a medical examiner had looked at the dog. And yet the prosecution, knowing this, argued that it was a calling card of Joey Watkins because he shot the man he murdered and then put his calling card by shooting the dog and putting it on the man's grave. And as it turns out, the GBI and the prosecution team knew that the dog had a different bullet in his head than what was used to kill the man for which Joey Watkins was convicted. So it was no calling card. They never produced the exonerating exculpatory evidence that they were required to produce under Brady, and had the bullet and the report in the courtroom at the time Joey was being convicted and did not produce it. That is mind-boggling to me that a prosecutor would do that. And the prosecutor, who I believe is now a judge, testified at the habeas as well. And the habeas court said, no, he deserves a new trial for that. So it was argued. So the AG's office went on and appealed, argued this morning. And I want to mention that from the time habeas was granted by the habeas court on April 11, the appeal now, October 4, that's still 6 more months in prison Joey Watkins has had to serve. He's now served over 20 years in prison for a crime he likely did not commit, and for based on really pretty crappy evidence. And so I'm hoping the Georgia Supreme Court does the right thing and affirms the habeas court, but we're going to see. And it's just another case to watch out for, but it's a striking case. It was the subject matter of one of the seasons of the Undisclosed podcast, and that's where I first got interested in it. And then
it's amazing how many more protections there are in civil cases than there are in criminal cases. You know, the Georgia legislature this past session for the first time, and I think in 2011, when I was president of State Bar, we passed the evidence code, which made the Daubert standard, which is used in federal court to outlaw junk science law in state court, but it was specifically exempted from criminal cases until this last legislative session. And you know, most of these cases that are getting overturned the cold case convictions that are getting thrown out on scientific evidence.
Right.
And it just became impossible to justify, treating a suit over money with greater care than a lawsuit over a person's life.
Absolutely.
And, it's pretty incredible.
Yeah. Well, that's a case to watch. I don't know how long it will take the Supreme Court to get an opinion out, but just go, if you want to watch that argument, you can watch it on the Georgia Supreme Court's website, and we'll be following that.
All right.
That's all I have, Lester. Do you have anything else?
I don't have anything else. Just want to say happy birthday to you again. And
thank you.
And I guess until next time, we'll see you in court.
See you in court.
Thank you for listening to See You in Court, brought to you by the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Please subscribe to this podcast and consider writing a review. You may find related documents to this week's episode on our website, seeyouincourt.podbean.com. Please send any questions, suggestions, or ideas to seeyouincourtpodcast@gmail.com. The producer of this podcast is Raz Misher. We thank Noreen Hassan, Associate Professor and Director of Outreach and Community Engagement at the Georgia Institute of Technology School of Literature, Media, and Communication, and the Georgia Tech students who help bring you this podcast. I'm Fred Smith, Executive Director of the Georgia Civil Justice Foundation. You may learn more about the foundation at fairplay.org. On behalf of Robin Fraser Clark and Lester Tate, until our next episode, we'll see you in court.